If you're comfortable with that.
That's fine. I guess I would also move to dismiss since he doesn't show up for his oral argument.
Al, that's just whether we take it on brief or not.
Okay. All right. I'm happy to address the court on the issue.
You need to go ahead and introduce yourself and then just give us whatever argument you want to give us.
Okay. May it please the court, I'm Michelle Sellers on behalf of the appellee, Dr. Timothy Love, in this matter. We submit that the court was correct in granting Dr. Love summary judgment based on the undisputed evidence in the record. There are 3 separate and distinct issues on appeal. Those are summary judgment granted to Dr. Love because Mr. Vilas' complaint was barred by the statute of limitations. The second issue is that the trial court properly granted Dr. Love's summary judgment because Mr. Vilas presented no evidence to create a genuine issue of material fact that he suffered any damages caused by Dr. Love in this case. And third, as an additional reason why Dr. Love is entitled to summary judgment in this case, Dr. Love submits that the trial court erred in denying his summary judgment on the separate and distinct issue that Mr. Vilas' pre-suit notice was a nullity because it was provided by an attorney not licensed to practice in Tennessee. Your Honor, because this is a medical malpractice action or healthcare liability case, the applicable statute of limitations is found in 2926.116A1. It provides that there is a 1-year statute of limitations. Then 2926.116A2 provides that if the alleged injury is not discovered within such 1-year period, the period of limitation shall be 1 year from the date of discovery. In this case, Your Honors, there is no dispute as to when Mr. Vilas was informed that he may not, his entire appendix may not have been removed.
Counsel, was he informed that that was somewhat typical of this procedure? If you have your appendix taken out, there may be part of the appendix that is still left inside of you.
No, and that's not part of the record in this case that he informed him that. The evidence in the record is that Mr. Vilas is aware that Dr. Love performed a laparoscopic appendectomy on March 19, 2017. He came to a post-operative visit on March 27, 2017, and at that post-operative visit, Dr. Love informed Mr. Vilas about the results of the pathology report, which state that there's no clear appendiceal mucosa within the specimen, meaning that it doesn't appear that there's any appendix. He didn't remove the appendix.
Did the physician explain that? And you just explained meaning
Yes.
X. Did the doctor in this case explain what the pathology report meant, or was the pathology report just provided and essentially the medical jargon and lingo was what the patient got?
No, Your Honor, he actually explained it. His record and his testimony is that they had an extensive discussion about the results of the pathology report at the post-operative visit.
Is that a disputed fact in this case?
It is not. It is not. And I can point you to the testimony. I know that the appellant has said that it's disputed as to whether he was informed of these things. But if you look at the actual entire testimony on these issues from Mr. Vilas, there is no dispute. If you look at as to whether he was informed that there was no clear appendiceal mucosa within the specimen submitted to pathology, that's on page 73 and 74 of the record. The testimony was question, his note from March 27, 2017 said that he has had a long discussion with you about the pathology results. Then he goes on to ask him question, goes on down, question. His note says that he told you that there was no clear appendiceal mucosa within the specimen submitted to pathology. Did he tell you that? And what the patient, Mr. Vilas, actually says is, answer, I don't recall. But Dr. Love's testimony is that he did tell him about the pathology report and the explained it to him during that post-operative visit.
So the record would support that that the physician in this case is going to say, I explained what that pathology report meant, and I told him that I didn't actually remove his appendix.
What he says is that, let me get to the actual testimony because I don't want to mislead the court. Dr. Love told Mr. Vilas that there was a small chance that the severe inflammation and scarring obscured his view. Lymphatic tissue was removed and not the entire appendix. So what we have, Your Honors, is a patient who has undergone a laparoscopic appendectomy to remove his appendix on March 19th. He comes back on March 27th and he's told that the pathology says that the entire appendix may not have been removed.
Isn't there a significant gap between there's a small chance that part of your appendix is still there as part of the procedure because I couldn't really see, and I didn't remove your appendix at all as part of this procedure, in terms of whether the patient is on notice that we have malpractice in this case? And those seems like there's a pretty big gulf between I couldn't quite see the whole thing, there may be a little piece of it still there, and hey, I know you came in to have your appendix out and I didn't actually take out your appendix. And that seems like a pretty big chasm to me between those two things.
We submit that it's not, Your Honor. He had an appendectomy to remove, a laparoscopic appendectomy to remove his appendix. He was told at the post-operative visit that his entire appendix may not have been removed. That puts him on notice. He doesn't have to be sure that his appendix was not removed. He doesn't have to know that it was a violation of the standard of care. What he has to know is he has to have, according to the Tennessee Supreme Court, he has to have some knowledge, enough knowledge to put him on notice. And that's enough knowledge to put him on notice. It's not a huge amount of knowledge. It just has to be some small piece of knowledge to put him on notice about
something that a reasonable juror, reasonable fact finder could disagree about, whether that's enough. And could there be is there room for reasonable disagreement on whether that information that there might be some of the appendix there is sufficient to put him on notice?
No, Your Honor, and that was not argued by the appellant, by Mr. Vilas, in the trial court either. He argued that it was disputed, which it was not. He argued it was disputed based on his testimony initially that no, he was not told that. But ultimately, when asked additional questions, it was clear that he didn't know whether he was told that part of his appendix may still be remaining or not.
Is that as close to equivocation as we've got here? And by that I mean the patient says at some juncture during his testimony that I don't recall. Is that essentially where we are in our analysis of the testimony?
He says, I don't recall. He says he doesn't believe he has a reason to dispute that he was told that. But ultimately, he says he doesn't know whether he was told that or not.
And what's the legal significance of that?
The legal significance of that is that he cannot create a genuine issue of material fact as to whether or not he was told this information, because he doesn't know whether or not he was told the information.
Well,
But the doctor
saying, I told him.
But the doctor
You've
says,
got the patient saying, I don't remember, essentially, or I don't recall. Is that enough for that to become a non-disputed material fact?
yes, Your Honor. Yes, Your Honor. It's not a disputed material fact because he doesn't know whether or not he was told. And the other testimony in the case is that he was told this information. They know that they told it to him. Not only did the doctor testify he told him the information, it's also included in his medical record from that day, which was dictated that day, transcribed that day.
The medical record, the terminology in the medical record is in essentially medical jargon, though, right? It's not, there's not a plain language statement of, maybe I didn't take out your appendix during this procedure. And is that a correct assessment of the medical records, or is there a plain language statement that was handed to him?
The plain language that was provided to Mr. Vilas was that I told him that there was a possibility that the entirety of the appendix had not been removed. And in the record, it specifically states, that being said, there's a very small chance that the severe inflammation and scarring obscured our view and lymphatic tissue was removed and not the entire appendix. So we submit there's not a dispute as to when he was put on knowledge as to the injury, because he knew that he had a laparoscopic appendectomy performed by Dr. Love on the 19th, and he was informed as to the pathology reports and the potential that his entire appendix was not removed. And the statute of limitations is told, pursuant to the Supreme Court, only during the period when the plaintiff has no knowledge at all that a wrong has occurred, and as a reasonable person is not put on inquiry. He clearly has knowledge
When did you
that
say
he
the
could have.
statute began to run?
The statute ran on March 27, 2018. The court found that the plaintiff, Mr. Vilas, properly provided pre-suit notice in this case. And if you provide pre-suit notice properly, you get an additional 120 days past the statute of limitations. So the statute of limitations passed March 28, 2017, but if he had properly complied with the pre-suit notice, he gets an additional 120 days, so it's July 25th of 2018, and this complaint was not filed until August 6th of 2018.
When did the plaintiff send pre-suit notice?
Plaintiff sent pre-suit notice on March 1 of 2018. And that goes into the third issue, which we submit that it was not proper because it was provided, just as an additional reason why he's entitled to summary judgment. The pre-suit notice was a nullity because it's provided by an attorney on his letterhead from Louisiana.
Counsel, what would you point to as requiring that pre-suit notice has to come from a Tennessee licensed attorney? What statute, what provision would you direct us towards?
Sure. The pre-suit notice is not required to be submitted by an attorney. It can be submitted by the patient himself. But in this case, it was provided by an attorney. And what the Tennessee Supreme Court has said is that if you're not licensed in Tennessee and you provide services basically in Tennessee, that's a nullity. And I believe we've cited to the 23-3108 that no person shall practice law in this state without first receiving a license issued by the Tennessee Supreme Court and complying with Tennessee Supreme Court Rule 6 concerning admission to practice law, and that proceedings in the case by a person not entitled to practice are a nullity.
So was the notice sent by the attorney, I believe from Louisiana, was that sent in his capacity as an attorney?
It was, Your Honor. The notice actually says the attorneys sending this are, and it lists Mr. Vilas, James Vilas.
And the attorney had not been admitted pro hoc?
No, Your Honor. He had not been admitted to practice in the state of Tennessee. He testified that he's never been admitted to practice anywhere except for Louisiana.
And the attorney is the father of the plaintiff, is that correct?
Yes, Your Honor. Yes, Your Honor. And everything was provided on his letterhead, his, sent by him. So we submit that that was the unauthorized practice of law. That's a nullity. That's just an additional reason why Dr. Love is entitled to summary judgment, because even under the plaintiff's argument about when he should be, when he knew or should have known about the alleged malpractice, because he didn't provide proper pre-suit notice, he doesn't get the 120 days, and so it's also outside the statute of limitations.
Was any discovery done about the notice itself, about, was the deposition of the Louisiana attorney taken, or?
Yes, Your Honor.
Did he agree he was sending it in his capacity as an attorney?
I do not remember if that's in the record, whether he agreed to that. He did testify he is not licensed to practice in Tennessee, and that he did send the notice in this case.
Thank you.
Thank you, Your Honor.
We will take this matter under advisement, review the record, and attempt to file an opinion at the earliest possible time.
Thank you.
Thank you. Call the next case, please, Ms. Angie.
Susan M. Austin